What's going on, everybody? This is Matt Maroff with my special guest today. My co-chair is Lee M. Perlman from New Jersey bankruptcy lawyer. Lee is a practicing bankruptcy attorney now since 1994.
Correct.
Since 1994. He has two associates exclusively concentrating in consumer bankruptcy, FCRA and FDCPA work. He has a staff of over 10 overseeing the 3 offices where they are consistently filing approximately 500 bankruptcy cases per year, which to me is pretty astounding with that. The 3 offices are in Cherry Hill, Mount Holly, and Toms River, New Jersey, correct?
Correct.
All right, cool. So Lee, let's jump into it because we have things we're going to talk about today.
Awesome.
We're also going to be talking. There's going to be, a discussion of open Q&A with people that want to ask questions. So I have the Short Sale 101 group, and I'm actually going to be pulling up my regular Facebook account also too. So I'm going to be bouncing back and forth between both Facebook accounts. So whether it's going to be on the Short Sale 101 group or the rather regular Facebook account. Lee Perlman and I met, I'm going to say 3 years ago.
3 or 4 years ago. And I appreciate you having me on today. I know how busy you are. Thank you.
No, I appreciate you coming on because I know how busy you are with your clients. But no, this is important. And Lee is basically our resident expert when it comes to the foreclosure process in Jersey. He actually has given us advice on, other states, and he's connected us with other attorneys across the United States. One thing I want to talk about that I want to make known is that Lee and I are going to hopefully put together a panel of other bankruptcy attorneys in other states, and Lee is basically going to be my co-host, and we're going to be interviewing other attorneys, other bankruptcy attorneys from other states, talk about a little bit about the process. Obviously, the process, it's the same, but there are obviously different state laws when it comes to sheriff sales and public auctions. So, Lee, without further ado, thanks so much for coming on. I really appreciate it.
No, thanks for having me. I think the idea to have a panel of other attorneys from different states makes a lot of sense. I mean, although bankruptcy, does involve federal law, the foreclosure timeline, as I like to say, the timeline for how quickly something gets to a sheriff's sale might be different in New Jersey, which is a judicial state, versus a non-judicial state where they don't have to file suit. So getting observations from some of the bankruptcy lawyers who are in the trenches from other states has been a goal of Matt's. I'm trying to help him facilitate that so we can get a panel together and really exchange information for consumers and homeowners so they know what's happening. Because, let's be frank, we're in a very, very difficult, challenging time. Matt has done a great job with his team, and Leah, I've watched their webinars of talking about what's going on in the trenches, what's going on with investors, and how mortgage companies are either honoring forbearances, declining forbearances. So your team, Matt, has done a great job of keeping people informed on that.
Well, Lee, I appreciate all the kind words. I was actually blushing behind the scenes right now. Not only kidding. Let's just jump right into it. And if people have questions, obviously they can ask them.
Sure.
Right. COVID-19.
Yeah.
Like, what's really going on behind the scenes, from the bankruptcy side? Because obviously people are contacting you and they're saying, look, I'm in trouble. What are you seeing on the front lines right now?
I'm seeing a lot of people who are in present Chapter 13s who are impacted by COVID-19. I have a number of clients who are in existing Chapter 13 cases with payment plans that they're having difficulty with because they've been furloughed, their hours have been reduced. In some cases, they've been laid off, and there's just a lot of uncertainty. Different industries don't know when they're bringing workers back. State guidelines differ. And foreclosures, as we know, are on hold, but clients don't know, when the other shoe is going to drop. And living with that kind of uncertainty, I live it with my clients every day, and trying to get them a little bit of relief, some kind of pause in their trustee payments. Because remember, these are clients who have been impacted, and under a Chapter 13, which we'll talk more about, a repayment bankruptcy, they're required to keep current both on their mortgage payments and their trustee payments. And when they need to take a pause because of a layoff or because of a furlough as it relates to those payments, it's difficult. And we have to give them advice when there's that uncertainty. Sometimes we have to go to the court and ask the court to suspend or pause payments until they know what's going to happen with their employment.
Yeah, so obviously, there is a lot of that going on right now, and the sheer panic with people with the COVID-19. When it all started, and you can agree or feel free to disagree with me, when everything was shutting down and the country was shutting down, they really should have done the right thing. What they probably should have done at that point is they really should have set up for a hard reset. They should have contacted the 3 credit bureaus and basically said, look, we are headed to a catastrophic time right now in our country. So we're going to ask from this date to this date not to report late payments, and or what they should have done was really offered a hard reset. Whereas we could have said, look, we're going to shut it down. We're going to shut it down from the stock exchange. We're going to shut it down from the financing companies, the leasing companies, and we're going to do a hard reset for 3 months. So, and obviously offer, the pandemic checks that they're offering people across the board. And it really shouldn't matter whether or not the person is on unemployment, not on unemployment. And I know as a small business owner, I try to, because, we are affected by it, but things are getting back on track. There's no shame in that. I've been depleting savings to basically, keep everybody paid and keep the company afloat. Got a marketing, budget and stuff like that, because I know that what's going to happen in the next 6 months to a year is going to be another blow to the United States. So I believe they should have done somewhat of a hard reset for 2 to 3 months, or they should have done at least a 60-day hard reset and said, look, everybody stay home for at least 30 days. And if you have the capability, or, put a curfew on people with their own businesses and stuff like that, because now unfortunately, people are talking about Chapter 7, the big boys. Some of the big boys are filing Chapter 7. Then you have local businesses that are not going to be able to open up, and they're not going to be able to sustain, paying the rent, and they're going out of business. What's your opinion on, what do you think the government could have done a little bit differently?
I think there could have been more of I think you're right. And I think generally there could have been more of an emphasis on making sure the relief was a little bit more widespread. So, for example, what we had from the CARES Act, which was the act that Congress passed towards the end of March, that provided for, PPP money and provided for extra unemployment. It provided that if you are if you're a Fannie Mae or Freddie Mac backed mortgage, which is about 3/4 of the mortgage in the United States, you're simply entitled to a forbearance, which is a pause in the payments, like you said, Matt. But it's not really a deferral. What they should have done, there should have been more we have to define our terms. So there's a difference between a forbearance, which is just a temporary pause in payments. And that forbearance can take a couple forms. It could say the end of the 3 months, you're responsible for the resumption of those payments. It could be spread out over a period of time. It's all going to vary depending on what you negotiate. But a deferral, like you were suggesting, those payments would be put at the back end of the note. So if there was some certainty and consistency across the board, I think you make an excellent point, Matt. Business owners like yourself and like me, all of whom have been impacted, would have been able to focus their resources on keeping their employees afloat and not having to worry so much about these mortgage payments and this, the mortgage is the main obligation that you have as an individual or a consumer. So the other significant point is that you know, 3/4 of the mortgage market is Fannie Mae or Freddie Mae backed. Those are the people who are eligible for the. What about the other quarter? I have clients who aren't eligible, and they have to go to the lender, and it's at their discretion.
Correct.
So I think the consistency part of this is very significant. We're dealing, as we all know, with a pandemic. People are afraid. People are sick. I have clients that are sick. And for them to have to worry so much about whether it's a forbearance, a deferral, and many of them don't have the opportunity or ability to go to a lawyer and get the kind of advice they need. So in the middle of all this, you have to reach out to an attorney where there may not be a relationship. So I think it's very burdensome for the consumer. And I think the government probably should have anticipated a little bit better how widespread the problem was.
All right, so we do have a question actually from somebody, and their question is, if you are in a Chapter 13, but you can afford to make more payments due to your income change, can you get out of the 13 earlier, and can you, I guess, accelerate it by sending more money towards a 13?
Yeah, that's a great question. So that's going to depend on the plan that you filed. I think your question goes to somebody who's not what I call COVID impacted, which is a term we use in our office. And typically, if you're in a Chapter 13, you're in a 36 or 60 month plan. If you're paying less than 100 cents on the dollar to your unsecured creditors, doctor and hospitals, credit cards, things like that, you're paying less than 100 cents on the dollar, and you want to get out of the case earlier than 36 months, there could be a penalty because you strike a bargain with the court, right? Your bargain is you're going to pay a percentage, and then 12 months in, you say, well, I want to get out early and I want to pay less than the original. So the trustee could potentially give you a difficult time. You always have to order a formal trustee payoff and see what the trustee's position is.
Okay, well, that makes sense. All right, well, we appreciate answering that question. Guys, if you have questions and, you're nervous or whatever, and you want to hit me, you could hit me privately on Facebook as well. I don't want anybody to feel like, we're outing people or people are asking questions that, people are going to question, their financial stability and anything like that. This is solely for putting it out there so people understand, what the opportunities are out there for them so they can find out really what their options are. So please don't feel in any way, shape, or form that you're being singled out. So if you have questions, absolutely, answer those. Ask whatever questions you have.
I think Matt's right. I mean, you want it to be informational. There's certainly anonymity. Happy to answer any questions, and it's not a reflection on what might be going on with you. Could be with a client. We don't look for any judgments. I wanted to talk a little bit about Chapter 13 generally, if that's okay. Yeah, Chapter 13 is an opportunity for you as the homeowner, if you've fallen behind, and a consumer, to keep ownership of your property, to stop a foreclosure. In New Jersey, if you file the bankruptcy prior to the sheriff's sale, you can stop the foreclosure. Now, as we sit here today, sheriff sales have been suspended as a consequence of the CARES Act and the governor. They haven't resumed. They're going to resume soon. I expect or anticipate there's going to be a resumption of sheriff sales within the next 30 to 60 days, from what I hear. So once you file the foreclosure, the bankruptcy, the Chapter 13, you stop the foreclosure, but you have to file the bankruptcy prior to the sheriff's sale. If you file the bankruptcy after the sheriff's sale takes place, you're going to lose the ability to cure the mortgage arrears over the Chapter 13 plan. So you file
real quickly, because some people don't understand how the chapter bankruptcies work. How long is a Chapter 13? How long can you be in a Chapter 13 for?
So presently, you can go ahead and schedule your arrears, which are the missed mortgage payments, in your Chapter 13 over a 36 or 60 month period of time. Now, if you're in a Chapter 13 now, and that case has been confirmed, and you are COVID impacted, you have an opportunity to take it out another 24 months. So you can extend your plan if you can prove that your hardship is related. You can take it out to 84 months, COVID impacted.
So if, let's just say for round numbers, somebody's paying $200 a month right now for a 5-year plan using round numbers. You're saying they could tack on an additional 2 years?
Yes, if you can, if your case has already been finalized by the court and you're paying back arrears, like in your example, Matt, of $200 a month, and
Right.
you demonstrate that you've been laid off, your hours have been reduced, and that's directly related to COVID, you can file a motion with the bankruptcy court to push it out to additional 24-month period of time.
Okay, so here's the next question, and I know nobody's going to answer this question, but I'm going to ask this question. What happens if they filed with the bankruptcy attorney and either the bankruptcy attorney has completely ghosted them, they've gotten their payment, they're not following up on Pacer, they're not doing their job, and guys, we'll talk about Pacer in a little bit, they're not doing their job, and they just don't like their attorney. Can a case be reopened with a different attorney?
So that's a great question. I guess the first example would be, let's say a consumer is in a Chapter 13 and something comes up. You make a great example. They've fallen behind. They can't make payments, or they just need advice in their case. And the attorney has, like you say, ghosted them. They can contact other counsel, and somebody can file, a new attorney could file a motion to substitute into that case to give that consumer the advice they may not have been getting from their present attorney.
The other thing I want to ask is, can somebody call you and ask for a free consultation?
Yeah, I'm practicing since 1994, both in my consumer cases and my small business cases. I do not charge a consultation fee. So right now, my meetings are being done telephonically, or we're conducting Zoom meetings, GoToMeeting, whatever the client prefers. But those meetings and consultations are just like you're in my office. And they're without a fee, without a charge.
Okay, so here's the other thing that I want to bring up, which I think is important. You know, everybody's always like, you know, in the beginning when we started doing business together, and they would say, "Oh, I'm going to go to so and so. He's an attorney locally." And I said, "Well, that's great." I said, "Well, Mr. Perlman, he's actually in Cherry Hill, New Jersey," and they would say, "Wow, that's really far." So now I think the days of where you're located really shouldn't matter, whether you're here or Kalamazoo. Because at this point, everything is really done, you know, virtually anyway, and you can do what you just said as far as a Zoom call.
The bankruptcy court, some other courts in New Jersey, you know, family court, criminal court, they've been closed as a consequence of COVID. Bankruptcy court has not closed one day. It was open the day after the pandemic, and those hearings are being conducted now remotely, mostly by telephone, some via Zoom. So I'm seeing clients, you know, from Cape May to Hackenstown. I mean, up in North Jersey, Bergen County, Essex County, Morris County, and we're able to have a meaningful conversation, and you don't have to drive down the turnpike to come and see me and save the fuel.
Save the fuel and the toll hike that's coming.
Oh my God, yes.
I'm never going to see you again physically, like. We're going to be able to, like, you know, like bump like elbows. You can't, and not for nothing, but you can't even really shake anybody's hand or hug anybody anyway. So what the hell's the difference?
It's a new world. No more hugs right now for you, Matt.
All right. Well, I'm not going to say I appreciate it. I'm actually pretty sad about it. Look, if somebody wants to reach out to you, Lee, they can call the office. Correct.
Correct.
All right, so the office number's up on the screen. Guys, I mean, I say things out loud because this is also going to be torn up and put into a podcast at a later date, which we're actually working on. If they want to reach out to Lee M. Perlman, you can reach him directly at the 856-751-4224. Again, it's 856-751-4224. Now, guys, this isn't a sales pitch for Lee's company. Lee works with the Real Estate Recovery Group. Lee is essentially, how do I say it? You are a resident foreclosure bankruptcy attorney specialist for Real Estate Recovery Group. So it's important for people to understand what their options are. And that's my whole, like, you know your options campaign, because people might be with an attorney they don't like, or maybe they went for a consultation from an attorney. And hold on, but are opportunities where attorneys give the wrong advice, bad advice, and it's mostly about money. So Lee is not like that, and obviously he helps us a lot, you know, with talking with people, which is, you know, we appreciate that. So if you have any questions or concerns, you can reach out to Lee directly after this. He actually has staff in the office, or the phone number is being redirected. So if you want to call during its time frame, that's fine. If you want to call later, that's great too. I don't see any other questions popping up right now, but people are logging on. So I'm assuming that we're doing a good job so far. So that's good. All right. So we went over the 13. All right. I know that there was one thing that I wanted to talk about where people, I don't think, really understand the difference between the two of these. And maybe we can, and hopefully I spelled this right. Dismissal versus a discharge of a bankruptcy. And that's kind of a pet peeve of myself and Leah, because we ask people, was it a dismissal? Did the stuff get dismissed? Or, it's just something that was discharged? And the homeowner really has nothing to say about it because they don't understand the difference of it, which to me is upsetting because, Lee, why do bankruptcy attorneys not explain all facets between a dismissal and a discharge, and what happens with a dismissal versus a discharge? Can you explain that?
Yeah, I just want to take a step back, if you're okay with it, and talk a little bit about, a Chapter 7. So we talked a little bit about a Chapter 13, which we call a reorganization or wage earners bankruptcy. We've really been talking about it in the context of how do we stop a foreclosure? How do we save your home? How do we pay back mortgage arrears?
Right.
So in a Chapter 13, typically you file, you have a hearing, and then your case gets confirmed. That's a designation where the judge says, in like Matt's example, your case is confirmed for $200 a month for 58 months. In a Chapter 13, that's a specific designation. Your case is confirmed. Usually maybe 4 to 6 months from the date of filing, the judge approves it. There's an order that's entered on the docket, on PACER, the court filing system, and then you make your payments. You're discharged after your 55th payment, after you make all your payments in a Chapter 13. Now, if during the pendency of your 13, you fall behind on payments, you don't meet your court obligation, the trustee files a motion, or the mortgage company, because you're not making your mortgage or trustee payments, your case can be dismissed, meaning not completed. So that's the difference between a dismissal, where your case is not complete, and then, like you say, Matt, you can have access to PACER and see on the docket if it's dismissed. Many times, lawyers that I know or I have dealings with won't explain the impact to the client of a dismissal, which I think is borderline ineffective assistance of counsel. You have to let your client know that the case has tanked or dismissed. I mean, that's the bottom line. If they're not meeting their obligations and the case has been dismissed, you have an affirmative duty to let your client know, A, that it's been dismissed, B, why it's dismissed, and C, is there an opportunity from that point in time to get the case reinstated, which means back on track before the dismissal, or in some cases, refile another case if you have a change in circumstances.
All right. So now, before you rudely interrupted me before, and you want to jump back to a Chapter 7 hotshot. Now we're talking about the dismissal versus the discharge of the bankruptcy. So why are so many homeowners so misinformed between the two of those?
Between the dismissal and discharge? Is that what you're wanting to know?
Yeah, because I'll ask a homeowner, I said, well, was your case dismissed or was it discharged? And they say, what's the difference?
Yeah.
Or they say, I don't know, I got a letter saying that it was dismissed for some reason.
You know, Matt, it's really, you're asking a really good question. And it seems to me that, and I mean, I hate to say it, but I really think it's just a failure of the attorney to communicate the bankruptcy process to them to understand. If you have an individual who's been in bankruptcy, either they're in bankruptcy or the bankruptcy for some reason not active, and they don't know the status of their case. I mean, it's like being represented by a criminal attorney and not knowing if you're guilty or not guilty. I don't get it. How can you not know that? And I don't blame the consumer. In that case, if the debtor has an attorney and the attorney hasn't communicated that basic information to them, I'm going to say right here, they're not doing their job.
Okay, so let's segue to something else. Last year, January, or two, I don't even remember at this point. I did my first ever short sale boot camp expo.
It was fantastic.
I appreciate that. You looked fantastic on stage. You look like somebody who's playing a role on in a movie set. You look like you had your blue glasses on. You look like Doc Hollywood. We talked about the people that were going to trusted attorneys and paying hard-earned money to pay for a service. And you blew the crowd away when I asked you how many filings of bankruptcies were filed correctly or incorrectly out of 10 filings. Now let me just, because this is important, out of 10 filings at that time, not talking now, well, so it's about a year and a half ago or so, people that were filing bankruptcies out of 10, how many of those bankruptcies were filed correctly?
I'm gonna harken back and think we talked about somewhere around 3 out of 10 were filed correctly. Is that what we said?
You said 2 to 3 out of filings for bankruptcies in the state of New Jersey were filed correctly. That meant
I would stand by that.
Correctly.
Yeah, I would stand by that. And you know what? Pessimistically, regrettably, I think that that's only going to get worse now, as some attorneys, and I've already seen some of this going on over the last couple months, now think they're going to decide to be bankruptcy specialists because things may not be busy right now with their area of concentration. So DWI attorneys who aren't busy because no one's going to weddings, bars, or graduations are sitting at home thinking, maybe I can be a bankruptcy attorney. I haven't been doing this for any amount of time. I certainly haven't been doing it 26 years. I'm going to jump in and see if I can file some bankruptcies now to help. It's like a dermatologist deciding that they want to do a colonoscopy. It's not going to go well.
Well, I mean, I wouldn't volunteer for that because I've had colonoscopies.
I had mine too.
Right, so it's kind of scary. We could talk, that could be a completely different segment.
Oh, that's a whole nother presentation.
If you could offer something like that where people could get a colonoscopy and throw in a free bankruptcy, I'll leave it at that. 8 out of 10 filings are filed, they're not filed correctly. So how scary is it that somebody goes to a local, bankruptcy attorney or talks to someone? How do you vet the process to find out whether somebody's actually a good attorney or not and knows what they're doing? How do you do that?
Yeah, and when we say not filed correctly, I think we're talking about a number of things. We're talking about an attorney who maybe has left significant assets out, maybe hasn't advised their client about the consequences of filing, potentially has selected a Chapter 7 when they have real estate, and maybe a Chapter 13 would have given them more flexibility. Mm-hmm. And certainly within that group is people who decide they think they can file a bankruptcy on their own, and the court generates a order that says you have to correct certain paperwork with the filing or the case is going to be dismissed. So in my small practice, I'd say 2 to 3 times a month, I'm getting involved in taking over another case, either from a prior attorney or sometimes from somebody who's pro se, who thought they could handle the case on their own and then have gotten into the case and don't understand the deadlines, don't understand how to file the paperwork, don't understand the means test, which is something you have to complete about income, and
Right.
they've just gotten in over their head.
Right. And obviously, that's scary because the average homeowner thinks that by filing a bankruptcy pro se, they're saving themselves money, which in reality, they're really giving themselves a huge headache because if they don't answer the information that's put in front of them within a timely manner, the bankruptcy is going to get dismissed. Now, if they try to go back in and file another bankruptcy, is something that I think that we should talk about because, there's always the, I guess, scarceness of people not understanding that if, and where is it here? We were just talking about it before about the bank, basically pulling the actual asset out of the bankruptcy.
Yeah, I think you make a couple of really good points. I think the first thing to really understand is that if you're filing the bankruptcy with an attorney, without an attorney, people need to remember that they think a bankruptcy is going to be a quick fix. And in some cases it is, because remember, bankruptcy is a very powerful tool. You file a bankruptcy, and in a 7 or 13, you have the availability of the automatic stay. You can stop the foreclosure. You can stop a bank levy. You can stop a wage garnishment. You can stop a sheriff from coming to your door. You can stop debt collectors so you can have an uninterrupted dinner with your family. Those are the benefits and powerful tools that the bankruptcy has. But then there are all of the requirements that you have either on your own, if you decide to do it on your own, or through the attorney. And this is where people really don't understand. All they see is the benefit of stopping these things. But then the hard work begins. There's a significant paperwork requirement. And you know that, Matt, from dealing with short sales. You guys and Leah have an incredible web-based system so that your documents and follow-up, it's perfecto. So I have a process that's different, but that captures the collection of the documents, making sure the documents get to the trustee, making sure they get to the appropriate people. And if you do not have a process in place to collect and send documents that are required and understand which documents you need and why, your case is going to get dismissed.
All right, look, one of the questions that popped up here is, can you file bankruptcy twice? Which leads me to the abandonment part.
Yep.
So if somebody files bankruptcy and the bankruptcy gets dismissed, then you try to go back in again, right? Yep. So now the creditor is saying, great, you can file bankruptcy again, but we're going to file a motion and we're going to file for abandonment. Now they actually take the property and actually reach in the bankruptcy and pull the property out. So now that asset is pulled out of the bankruptcy, which leads it to an abandonment. So now you're thinking you have coverage for it, and the bankruptcy attorney doesn't follow up on PACER and see that the property was physically pulled out, and they think, nah, you're covered. Everything's great. As a sale date comes, no, you're fine. Don't worry about it. Everything is great. And then they lose their house.
Yeah.
And in some cases, people file bankruptcy for that specific reason, to stay in their property, to try to keep their house. So how many bankruptcies can you really file in the state of New Jersey?
Well, you're asking all the right questions, and you always ask good questions, Matt.
I've been around the block once or twice.
But the question that I think I'd like to back up a little bit, I want to talk to you about an abandonment, and I want to talk about the automatic stay, because that's what you're asking. So in a bankruptcy, there's an automatic stay, and that protects the mortgage company from coming after you. But remember, they can file, when I say the mortgage company can file a motion to lift the automatic stay in a Chapter 7 or 13, or try to have the home abandoned, which means it's not in the bankruptcy estate's control. And then the home, it's almost like Matt said, it's almost like the home has been picked up and placed outside of the bankruptcy estate's protection. So, for instance, if you're in a Chapter 13 and you stop making mortgage payments when you're required to make them, the mortgage company is going to sweep right in and file a motion to lift the automatic stay so they can be back to where they were before the bankruptcy was filed. In a Chapter 7, remember, it's a short time frame. A Chapter 7 is not a 36 or 60-month repayment plan. I like to say a Chapter 7 has a shelf life of 6 months. File, hearing within a month, 2 or 3 months discharge. If you have real estate in a Chapter 7, you damn well better know what you're doing with it, because like Matt says, quickly the trustee is going to abandon it, and either A, you better have that short sale completed, you better have a loan modification, you better be current on the mortgage, or you better be prepared to surrender. I'll say them again. The Chapter 7 options when you have real estate are very limited, and most lawyers, I don't say most lawyers, many lawyers do not explain this, and they reflexively want to throw somebody in a Chapter 7 because they're going to accept the fee and not really drill down on what to do with the property. So either A, in the Chapter 7, you better have a loan mod, you better have the short sale ready, you better be prepared to give up the property, or you better be current. And there better not be too much equity in your property in a Chapter 7, or you're going to lose your house.
Okay, so you sound like you're getting upset there. I like that. Most people, for whatever reason, don't understand, again, the rules, regulations, and the guidelines when it comes to bankruptcy. And
I get a little fired up, sorry.
No, and that's okay. You get like me. And I get all that, right? So look, if people, if they're shy and they don't want to call the office, they can go to your website, which is NewJerseyBankruptcy.com. And they can obviously, go on there, fill out a questionnaire, take a look and see, who you are and everything like that. What's upsetting to me is the fact that you're getting upset because you see what I go through with homeowners when they're like, okay, look, I don't have a job. I can't qualify for a modification, but I'd like to try to stay in my house a little bit longer. That's fine. And then we tell them, look, that's great. The bankruptcy is going to be used as a tool, and we're going to be able to make it so you could stay in your house a little bit longer. So there's no real guarantee, but you would say about the average is usually about 6 months where the person would actually stay in the property, correct?
Yeah, I mean, look, they're going to file a motion, the mortgage company, to lift the stay. And
Right.
Then they're going to seek to put themselves in the position they were before the bankruptcy. If the homeowner hasn't addressed how they're going to handle the bankruptcy, how they're going to handle the real estate in the bankruptcy.
Right.
Do they have a short sale that's working? Maybe, as you know, when we've worked together, the lender will back off a little bit when they understand that process is underway.
Right.
You're going to get a loan modification package complete prior, even within the bank.
That's not good. Lee, are you there? Lee Perlman. All right, guys. Well, we're having a little technical difficulty. Hopefully, Leah will be popping back on. Lee is the attorney of choice for Real Estate Recovery Group in New Jersey, and obviously, he's been working with us diligently with our clients and letting them know what's going on. So, if you find somebody who is a possible candidate for a short sale, and they want to do a short sale, but they also want to try to file bankruptcy, that's fine too. I would definitely recommend having them speak with Lee and letting them find out what their options are. It's all about helping the homeowner, directing them into the right situation. We don't want to put people in bad situations. He did talk about if there is equity in the property, would a property actually be able to save them if there's equity in the house, doing some type of reorganization. And I know that one of the things we're going to talk about when Lee comes back is did they raise the limits for some of the bankruptcy options for 13? So that's going to be coming up next as well. I appreciate everybody's patience. Hopefully he'll be, bouncing on real quick here. We can get him back on. Uh-oh. Yeah. Lee just messaged me. He said that his internet has actually gone down in his office. Oh, here he is. And he's back. Thank God. Lee, what happened?
We have a really bad storm here. My internet just went down. We got thunder and lightning, and it's really coming down, cats and dogs.
Okay. I think that the other bankruptcy attorneys in New Jersey are trying to shut it down, and they're trying to shut the live feed down.
You know what? That's a very good theory.
They're trying to shut it down. Lee, let's talk a little bit about people that are in trouble where what was it, $1 million or $2 million if they wanted to try to file a 13 on their house?
Yeah, so there in a Chapter 13, there are certain debt limits. You can't have generally more than 500,000 or so. I think it's 4 and change of unsecured debt. I have to look at my code, and then $1.2 million of secured debt, like mortgages. If you're beyond that, you have to move to a Chapter 11. So under the CARES Act, they amended the small business section of the Chapter 11 to allow for a higher threshold of debt, moving it from the 1.2 or so million up to 7.5 million, and simplifying small business 11s. So
debt limits between Chapter 11 and Chapter 13. That's what we're talking about right now?
We are. So the opportunity to file a small business 11 or an individual 11 has gotten a little bit easier. Some of the, without getting too technical, some of the requirements about how the trustee works and quarterly fees, it's been simplified a little bit to make reorganizing for people who have debt of 7.5 million and less easier.
So if somebody's actually reached out to me in the past or reached out to you in the past regarding the debt limits, they should definitely reach back to you. And
I think now, now's the time to take a look again at the debt limits and their income and expenses and see if putting them into a small business 11, what they call subchapter 5, makes sense.
Okay, cool. All right, guys. So debt limits on Chapter 11s and 13s have been altered. And this was effective when, Lee?
This was effective with the CARES Act towards the end of March.
Okay, so as of late March.
Correct.
So that's what, 3 months ago?
About 3 months, yep.
All right, so guys, if you don't know, and look, if you're working with an attorney now and your attorney hasn't spoken to you about it, reach out to your bankruptcy attorney and ask them, what their opinion is. This is all about information, guys. This isn't necessarily pushing everybody in Lee's direction. Lee came on here to kind of his heart because he sees that we're struggling with homeowners that really don't understand what their rights are, and they really need to know. And some people, for whatever reason, they don't like to follow up. Hold on, there's a question here. Got cut off, but it said, I've met homeowners who have filed for bankruptcy, never pay on their mortgage, and let's see, they're paying their mortgage. The home begins to fall apart. They can't get approved for any loan mod or refinancing. What is their logic? And I quote, oh, this is funny as hell. I can live in the house for 10 years for free. What would you say to somebody, as I call them, get-overs, that wants to live in their property for free? And guys, by the way, Peterson, question for you. What state is that house in that you're talking about where they're saying they can live the house for 10 years for free? And the reason why I ask is because some people still don't know. Lee, last year, November 2019, they actually changed or they tweaked a little bit as far as the bankruptcy, the foreclosure law in New Jersey, correct?
They did, yeah.
So November 2019, I'll put this on here so people can follow along. On the foreclosure laws in New Jersey. They've changed. How they changed?
Well, what they did was one of the main things they did was they have increased how quickly foreclosures can get to sheriff sales. They've made it easier to secure foreclosure judgments for the mortgagee, the person who's bringing the foreclosure action. They can bring them closer to the foreclosure judgment more quickly, the sheriff sale. Now, the opportunity to adjourn sheriff sales used to be at 2-week cycles. They've extended that, so they're month cycles. So you have a little bit more time, but after a couple of adjournments at month cycles, the mortgage companies are gonna be required now to get those sales scheduled. They can't be indefinitely adjourned like they were being done before. Yeah, you're gonna have to go in front of a judge for that.
So here's what I'm saying. So in the state of New Jersey, you get 2 adjournments. It used to be 2-2-week.
Right.
It was 30 days. Now
Right.
it's actually 60 days.
Correct.
You get
Correct.
2 30s. And after that, they have the opportunity. They can go in front of a judge and they can ask for what's called an urgent motion, correct?
Correct. Correct. And that really can't be done. You know, previously you pick up the phone and you'll work it out and you request it from the lender. Their hands are going to be tied now, and they're going to have to go in front of the judge, even if there's consent from both parties, and someone's going to have to make an application, file something with the Chancery Division of the foreclosure unit, making a joint request for more time. So
Right.
you have to be careful about that.
Now, here's the thing that most people don't understand and they don't know, which I would say, you know, after doing this for so long, what would you say to somebody that if they file the 2 adjournments, then they have the urgent motion, right? Then they go in front of, quote unquote, the judge, and the urgent motion's gone, the 2 adjournments are gone. The judge actually has and can have the right to pull the trigger and say, look, we have the numbers in here, right? We have the upset number. We know what the numbers are. We have the information from the bankruptcy attorney. They can actually foreclose.
They can. I mean, in your example, is the person in a bankruptcy or not in a bankruptcy?
I'm talking no bankruptcy. I'm talking about they've used 2 adjournments. They've filed an urgent motion. And you know what? Screw it. Let's throw the fact that they are in a bankruptcy. But during that bankruptcy, right, the automatic stay got pulled off, right? And the abandonment was put in place. So they think they have the coverage, but they don't. And
Yeah.
that's where I think Real Estate Recovery Group prevails. And one of the reasons is because we've actually been lucky enough to actually pull a property back from when it's actually been foreclosed on and basically reverse the foreclosure. I don't think many people can do that because they don't understand the laws and stuff like that.
No, I mean that's pretty far along down the field, and to get that done is a pretty remarkable feat. So
we can agree that's kind of sexy, right?
I love it. I love
Okay.
it. You mentioned before, and I wanted to return to one of your earlier questions that I didn't get a chance to address about multiple filings, because it's really a good question. And your question is, let's pick a scenario that I have, you know, a dozen times a year, where somebody comes to me, they file pro se, or they filed with an attorney who hasn't explained the process to them, and now they come to me and they want to file again. So usually, you know, the easy case is if they come to me and they want to file again and they have what they call changed circumstances. Their budget has changed, their income's changed. That's really what I call a no-brainer. That's very easy to file another case because I can show the court there's a change from the previous case to the new case. Because remember, the creditor is looking at this through, you know, a different lens than the debtor's counsel or the homeowner, the debtor. They are saying, all right, they filed a new case. What's different about this case versus the last case? That's the change in circumstance standard that the bankruptcy judge looks at it. We can say, well, their income's higher now. They'll have an ability to do a loan modification. They can cure their mortgage payments over a period of time because they have more income and expenses to make the payments. That's terrific. That motion's getting granted. That new bankruptcy will likely be confirmed or approved. But if they come to you and nothing's changed, then I have to make the argument to the court that the prior attorney didn't do what he was supposed to do. He didn't explain the consequences of dismissal versus discharge, or the client filed himself and got in over his head, judge, and now he's come to an attorney and we're going to handle the documents. We're going to handle the filing. We've explained things to him, and we have to file a very detailed certification, have a separate hearing. This is a separate bankruptcy hearing. When you refile, you have to file a motion to what's called continue the stay and explain changed circumstances. And the mortgage company, the trustee, or any creditor can come in and say, you know, I don't know. I don't know whether there's sufficient changed circumstances. They are a serial filer, Judge, and I don't think they should be entitled to file again. They haven't demonstrated changed circumstances.
So this would obviously apply to the question that this gentleman Peterson had asked about people that, you know, maybe they made a couple of payments and said, screw it, I'm not going to pay my mortgage. And they've basically been in the house for 10 years. I mean, at some point, the bank has to realize that the people are committing fraud, or that they can't say it, obviously, but a file can be flagged for fraud. We've actually been brought into cases where a real estate agent and or another attorney was trying to work on a file and said, oh, we can't get it done. They won't work with us. And then we call and we talk to them. And then, yes, we're very fortunate. I'm not going to lie. We have substantial contacts inside the bank. And as long as we have authorization, they are willing to talk with us and we can get information. Platform notes and a file, huge. Just like Don says, just like Donnie says, huge. And the reason why it's huge is because we understand what the bank is looking for as far as, you know, doing any type of loss mitigation, whether it's a loan modification or whether it's going to be liquidation option. But I want to jump ahead because this is important, okay? A look back before you file bankruptcy. People ask me this question. I know that there is a little bit of a look back on it, but how real is it that if somebody wants to file bankruptcy, and let me just set the stage so we're on the same page. Okay, 2 years, somebody knows that basically they have a failing business. Let's say the business is without question going to fail, and they're almost, you know, they're preempting the fact that they're going to have to file bankruptcy. So they start moving assets out of their names and moving assets around. The bankruptcy court is not stupid. So my question is there really a look back when you're filing a bankruptcy? And is it really?
Absolutely. The conduct that you have before you file is very significant. In that situation, that would probably fall under the New Jersey fraudulent transfer statute, because there's a spot in the petition. It's called the Statement of Financial Affairs. It's a list of 25 questions, 25, that you have to answer under penalty of perjury. Have you transferred property to anybody within the last 4 years? How much was it for? Because creditors have a right to know if certain assets were transferred, they can go ahead and unwind that transfer because that's money that otherwise would have been available to creditors. So transferring assets, moving a deed into somebody else's name, things like that have been contemplated and have been memorialized in the bankruptcy code to prevent bankruptcy fraud. That's one of the most significant areas of bankruptcy fraud, transferring assets before you file. So in terms of a look back, and it's really a misnomer to say that you're going to sit down with somebody and you're going to do pre-bankruptcy planning. Look, every lawyer has a different opinion. My opinion has always been that's a catchphrase for bankruptcy fraud, which is not anything that my firm's involved in. So if you're going to sit down with a bankruptcy attorney and the attorney is going to advise you how to move assets, that attorney could be complicit in a bankruptcy crime. Right.
Got it. So basically you would tell someone if you're planning on doing it, don't do it.
Yeah.
I mean,
look, there might be an example. Sorry, go ahead. You had.
I was going to say. I mean, the upside to it is that, you know, you might get 3 to 5 years with having, you know, 3 square meals a day. You don't have to worry about laundry and lodging, and you know, basically you get your laundry done for free.
If you disclose in bankruptcy, everything is about notice and disclosure. So right. Let's just take 2 examples of a transfer. If you transferred a business and the business at the time you transferred it was worth $25,000, looking at assets, inventory, equipment, receivables. You did an analysis and said, at the time I transferred my business to Mr. Smith 2 years ago, and you describe that on your chapter 13, and you're paying creditors a certain amount. If you're paying creditors, and I don't want to get too detailed,
No.
the same amount that you otherwise would have paid them if you were going to liquidate, and you paid those creditors a certain amount, in a Chapter 13, you can transfer the business. You just have to pay creditors for the value of the transfer. Now, in a Chapter 7, if you transfer that business and the trustee discovers that and you haven't disclosed it when you otherwise should have, they can go back to unwind that transaction. They can sue that business owner for the recovery of the transfer. So the trustee has a lot of broad powers there, that if you haven't disclosed that to your attorney, or if you haven't, he hasn't explained it, you could potentially have a big problem.
Yeah, no, 100%. One of the questions that popped up here, and I actually wrote it down because I think it's pretty important. Did we cover how many times you can file a bankruptcy?
Oh, we didn't, but I can certainly talk to you about that. So generally for Chapter 7, once every 8 years, and for Chapter 13, usually 2 to 4 years, depending on how much you paid your creditors back.
Okay, well, that's good. All right, so this is one of the questions that I probably get at least every other day. Can you file bankruptcy without a lawyer?
So I often tell clients that you can stitch yourself up, but it doesn't always go super well. So the answer is
proceed with caution.
Yeah, the answer is yes, but there's just a lot of different there are a lot of different pressure points in the bankruptcy, in the 7 and the 13, that that can be pretty consequential for you. Understanding the means test, knowing about the class that you have to take, the 2 classes. And if you miss any of these deadlines, the court's going to generate a dismissal motion. And then, you could potentially be barred from filing another bankruptcy if you didn't handle the first case correctly. In a Chapter 13, filing a Chapter 13 pro se, I think, is a big mistake. Can you do it in a simple 7? Sometimes you can. I have seen clients get it done, but there are statistics that the clerk's office put out, and they have statistics on pro se filings, and the success rate, it's not so good.
So basically, you could extract your own teeth, but you really should go to a dentist to get it done. Is that what you're saying?
I think that's a very good analogy.
What happens if somebody doesn't have the money to pay for the bankruptcy? That's a huge thing.
Yeah, I mean, in a Chapter 7, I've always been very flexible in terms of fees. I mean, I have clients in Chapter 7 that are on Social Security disability. We try to figure out a payment plan that's suitable relative to their income. In a Chapter 13, the lawyer has the ability to put fees into the Chapter 13 plan, and he has flexibility. Fees for Chapter 13 are set by the court. They're $47.50. And the reason they're $47.50 is because the court knows that the lawyer is going to be involved for a 36 or 60-month period of time. Most lawyers take a portion of the fee up front and then build fees into the Chapter 13 plan. If a client wants to pay me in full before the filing, I'm okay with that. But most of the time, fees are put into the Chapter 13 plan. In a Chapter 7, the lawyer must be paid before he files. Otherwise, he's a creditor, and that's prohibited. So we're a little different than most firms, and we'll start preparing a Chapter 7 before the whole fee's paid. We'll accept creditor calls, communicate with creditors. We'll do everything that we're allowed to do to help out without filing. Most lawyers say, I'm not doing anything without the entire fee. We have flexibility. Can't file, but we can certainly, put you on a payment plan.
Okay. So, look, the reason for doing this type of live and adding the information and showing people is so everybody can understand what the options are for them, for their clients, for whoever. I had mentioned early on in this live that I wanted to do something outside with outside counsel or attorneys. We are looking for bankruptcy attorneys for a panel that we're going to be doing. We're also going to be looking for attorneys that are going to want to come on, and we're going to set this up probably every 30 days, Lee, where you're going to be, my co-host, and we're going to talk with other attorneys, hopefully in other states. Now, I've gotten some ticklers, some people that are interested. I'd love to hear from people that are watching this, and they don't have to respond now. What states do they want to hear from bankruptcy attorneys, if anything? I know that we have people that we're working on right now in Pennsylvania and New York, but not confirmed. We are confirmed with Pennsylvania with an attorney?
I think we are. Yeah, we're working to get that firmed up, but we're very close.
Okay, so we have a Pennsylvania attorney. We are looking for a New York bankruptcy attorney. We are looking for a bankruptcy attorney in Connecticut. And basically, I'd love to go all the way down the line if we can, and then maybe hopefully go over across the United States. That'd be kind of cool. So that's something that is a little bit of a dream for me. I told Lee about it, and Lee said it's crazy, but that's basically your format and how you like to do things differently than everybody else. These are things that people don't talk about. And yet, like Lee said, it is federal. So it's the same, but in each state, the foreclosure laws are different, and everybody has a different spin. So I think it's important, and I think it'll be great content for the viewers that come on here that watch the live. We've had a ton of people pop in and out off of this. So you are based in New Jersey. You are licensed in the state of New Jersey, correct?
Correct.
That doesn't mean that you can refer somebody from another state in your network. So if somebody says, hey, Lee, I've got a situation in Mississippi, can you refer anybody? So if they wanted to in the New Jersey aspect, they could reach out to you, correct?
Yeah, I'm affiliated with several national bankruptcy groups that, do good work, and I'm comfortable getting somebody a referral. Sure.
All right, cool. Well, that's important. Most people don't want to do that. So let's see here. In 2007, South Jersey Magazine, Awesome Attorneys. What's that?
So locally, there are a couple. There's South Jersey Magazine. A couple of the local magazines have recognized me as an awesome attorney. Last year, there's only 1% of the bankruptcy lawyers designated as super lawyers in consumer work. I was one of them for the first time in 2019, 2020. So I'm proud of that designation. So yeah, we have a number of Google reviews. We're pretty transparent. You can't please everybody, but we try hard.
Gotcha. I guess if nobody has any other questions, we pretty much covered everything that we wanted to cover. And I appreciate, everybody that, did participate and sent me instant messages and wanted me to answer some of the questions. It was great. I think the open forum today, I want to quote a success. What do you think, Lee?
I think it's great. You just make it so easy to have a conversation, and I appreciate you having me on. It was really a pleasure.
You tell my wife that?
Of course.
Look, at the end of the day, guys, it's not about Lee. It's not about me. It's about offering a service and letting people know what's out there. Look, most people didn't know about Matt Marinoff in 2005 when I came onto the scene. When I decided to start really, branding myself, and I started teaching classes in 2007, people were lining up, which was great. Then I went dark for many years, and I worked behind the scenes with a lot of investors, and then and talking with homeowners and letting them know what their options are. For 5 years, I reemerged, and I started my nationwide campaign to help other people across the United States. I'm actually getting chills right now, which usually they say when you get chills, that means that there's a presence in the room with you. I don't know if that's true or not. So hopefully it's somebody good and not bad. I don't need the Grim Reaper coming in my office right now. As far as the services that we provide, we are providing a nationwide service. Lee is our resident bankruptcy attorney in the state of New Jersey. We are looking for people to network with us going forward for doing panels that we're going to do with other states and or bringing on individual attorneys from other states regarding bankruptcy. So my guest today was Lee M. Perlman. He is a licensed bankruptcy attorney in the state of New Jersey since 1994. You can reach out to Lee's office directly at the 856-751-4224 number. It's 856-751-4224 number, and you can get a free consultation or at least find out your options. Look, if you're a real estate agent, if you're an attorney, if you're a regular attorney, if you're an investor, if you're a homeowner, why not find out what options are available out there for you? Lee, any parting messages or?
No, I just want everyone to stay safe and well, and I can also be reached. You can certainly check out our website, which we've just revamped at NewJerseyBankruptcy.com, which is all spelled out, NewJerseyBankruptcy.com. And Matt, this has been a pleasure. I've really liked this today.
Is that the website there, New Jersey Bankruptcy?
Yep. Yes, sir.
Okay, so that's the bankruptcy. Guys, so if you want to reach out to Lee directly, also for the bankruptcy, his website is NewJerseyBankruptcy.com. Very lucky to get that website there, young fellow. And Lee, at the end of every single one of these lives, I ask people to emulate my finger point. So I'd love to see if you can do it. I don't know who you're pointing at. There it is. I'll give you a 7.
I'll take it.
Next time you go out in the sun, you might want to put a little lotion on your face, my man.
Thank you.
Lee, thanks so much for coming on today. I really appreciate it.
Appreciate it. Thank you, my friend. I really appreciate it.
Hold on, guys. Lee, hold on one sec. Guys, remember, this is Matt Marino for Real Estate Recovery Group. Every day we're doing lives. We are cutting back Monday through Friday now. We're going to be doing Tuesday through Fridays. Monday next week was already something that was already set up. We're going to have Chris Coronata from the Coronata Property Group. He's actually a racing realtor in New Jersey. He actually races a race car. So that should be a very fun interview to have. But we have more guests coming up later on the week. So stay tuned. Guys, have a wonderful day. I'll talk to you soon. It's Matt Marino for Real Estate Recovery Group. Remember, it is not a no until you get a restraining order.
Thank you, Matt.